said the elements of criminal liability. What I remember clearly is that we said generally every criminal offense has two components, or what we call elements. The first being the physical element, and the second being the mental element. The physical element is known in Latin as the actus reus, and the mental element is known as mens rea. We said when we talk about actus reus, it is the physical action or inaction or condition or state of affairs of the actor, that is the accused person. And that physical action or inaction must have been prohibited by law. So that when the person engages in any action that has been prohibited, that constitutes the physical element. Now, we did underscore the fact that nobody commits a crime involuntarily. Before the person commits the crime, the person must have formed some guilty mind, which is that the action that we see is almost always a manifestation of some intention or some idea in the person's mind. So that before you kill somebody, you must have given that killing some mental deliberation or thought. So the mental deliberation is what constitutes the mens rea. You decided to kill. That is why you prepared for the killing. And we came to look at types of intent or intention. We talked about direct intent. We talked about oblique intent. We talked about intermediate or indeterminate, right? Indeterminate intent. Then we looked at, pardon me? Specific and transferred. Please, these are not difficult theories. They are things you can see and understand with the help of your minds. Today, we want to look at a very important concept in criminal law, which we use in court to determine causes of events. We use in court as a conceptual tool to determine cause or causes of events. I have mentioned it to you before that there are some offenses that are classified as result crimes. When we say result crimes, we are talking about those crimes that can never be said to have been committed unless some result occurs. That crime can never be said to have been committed unless some result has occurred. A typical example of result crime is murder and all manslaughter. Now, when we say murder, under sections 46 and 47 of the Criminal Offences Act, Act 29, murder is defined as the intentional killing of another person by harm which is unlawful. So when you intentionally cause harm to another person and that harm is unlawful and that harm leads to the death of your victim, we say you have committed what? Murder. Now, if you cause harm intentionally and the harm is unlawful and your victim does not succumb to the harm, your victim does not die, can we talk of murder? Yes, because that which must happen for murder to occur is death. So until the person dies, you cannot be said to have committed or caused murder. So now when we go to court, in murder cases, a very important stage of the judicial inquiry is trying to find out what caused the death. What caused the death? We practitioners appreciate the fact that there are usually multiple causes of events, especially death. So, I shot him, for example, in the chest. I shot him in the chest. Then he was bleeding profusely, and a passerby wanted to assist a pragya rider. So he was forced into the pragya, and the rider had to rush because of your condition to the hospital. Now, on the way to the hospital, there was